I will just share my slides. Can you just allow me to share my slides?
Please share your project, ma'am.
Okay.
Now we resume our next session on hands-on training on AR in IPR by Dr. Professor Prajakta Kani ma'am. Now I request Dr. Babu Gopal sir to introduce ma'am.
Hello.
I hope you can see my slides and my video.
इथला आवाज येतो का मॅडम? Arun, you speak from here. नाही येईल ना. मॅडम आवाज येतोय का?
हो येतोय येतोय.
Good afternoon. I welcome you all in the fourth session of second day of this FD. Here I am in front of you to introduce today's expert for this session. Professor Prajakta Kani. She is currently working as Assistant Professor of Law, Assistant Dean, and Doctoral Scholar at Jindal Global Law School. She holds LLM from Queen Mary University of London with specialization in cyber law, IPR, and international banking. She pursued her undergraduate studies in LLB and engineering, that is B in information technology from Dr. Babasaheb Ambedkar, Marathwada University, Aurangabad, and has consistently excelled in academics. Her area of interest is at intersection of technology and infrastructure. She has research on machine ethics and is curious about studying legal aspects of technologies like AI, machine learning, blockchain, and other legal issues concerning technology. With data protection, IP, cyber crime, cyber security, and has published at international and national level. Prior to joining Jindal Global Law School, she has worked for Q Legal, the legal advice center of Queen Mary University of London, which provides free legal advice to tech startup companies and entrepreneurs. As part of this assembly, the externed with Belgium-based technological startup Lorraine, where she worked on AI-based legal chatbot for UK market. She is recipient of 2018-19 Prescale Essay Prize for Best Legal Essay on Computer and Communication Law subject, as judged by Prescale and Compass LLP London. She was selected as student leader in 21st Indian Student Parliament at Pune, where she presented her views on women empowerment and got an opportunity to visit significant organizations, International Court of Justice and International Criminal Court at the Netherlands, UNESCO headquarters at Paris, WTO headquarters in New York, Commonwealth Secretariat at London, the European Parliament, and NATO headquartered at Brussels. This international exposure in the early stage of career influenced her thought process and triggered her to make shift from purely technical domain to the humanities and social sciences. Here I am presenting you some papers published by her. Patents in metaverse and analysis of scope and challenges in 2024. Analysis of complexities in patenting AI and big data inventions 2023. Is raising legal age of marriage for Indian women the aspect in 2022. Smart contracts and blockchain, legal issue implications for Indian contract law in 2021. The Election Commission of India is in need of urgent reform in 2021. Gender sensitization and cyberbullying in 2020. So I welcome you all and our today's expert, Professor Project Apply, for this fourth and last session of second year of Adult. Thank you.
Thank you. Thank you so much for your kind welcome. I'm really honored to be part of this FDP. I hope I'm clearly audible before we start with our today's session.
Yes, ma'am.
Okay, thank you. So I have prepared a short presentation. Now, because this is just a 1 hour session and the focus ought to be on the practical aspects, I would be majorly focusing on the domain of patent law, although broadly we would be discussing the intersections of artificial intelligence and IPR. Okay. So, IP, when you say intellectual property, right? So, what it is exactly, it is a right held by a human or legal person. What this right is about, it is about some sort of intangible property. Intangible, something which you cannot see or touch. So that is related to your brain, the product of your brain, the product of your intellect. So intellectual property is the product of your intellect, right? And there are different categories of these right, which all of you must be aware of. So patents, copyright, trademarks, design. Okay. And now, when we talk about artificial intelligence, AI, to understand it very simplistically and in literal terms, it is about emulating human brain. So, whatever a human brain is capable of doing, that is done through help of computer machines, right? So this is a broader understanding of AI. Now, on a very fundamental level, how intellectual property and AI are related. Now, intellectual property, we discussed, it is intellectual labor. It is a product of intellectual exercise of your brain, right? So something is created, something is invented from your intellect, okay? From it is the product of the intellect of the brain, right? And AI, which is a technology which is about emulating the human brain. So just as human can think, human can act, human can perform certain actions, AI aims to do so, and of course, with greater proficiency and efficiency. So, at a very fundamental level, there is a great intersection between IP and AI. Okay, now moving on to different categories of intellectual property and how they are related to AI. Okay, as I said, we would be focusing on the aspect of patent, right? But let me give you a glimpse of how AI raises potential issues and also how it is being used even positively when it comes to regard of trademark and copyright. Okay, so trademark, as you know, it is a type of intellectual property. What exactly is a trademark? A trademark consists of certain symbols. It consists of certain numbers, alphabets, right? It is clubbing of certain numbers, alphabets, or it could be a figure. So the cut apple on the Apple iPhone, right? That is the trademark of Apple company. The tilted E in the Dell product, right? So that Dell is a trademark. So what basically a trademark does, it helps customers to associate, to form an association with that product. So when you see a trademark, so there must be numerous smartphones, but how you will distinguish an iPhone? You would look for that mark of an apple, right? So there is some kind of an association. How this association this association is of trust. Okay, so the basic function of trademark is to impose that brand value, is to impose that trust into consumers, that yes, whatever product I am choosing, if this is the trademark, surely it contains certain value, it contains a specific quality standard, right? So this is why trademark are used, and it is protected as intellectual property. Okay, now how AI is related to trademark? Now, artificial intelligence that we discussed, it has, why it is exceptional today and why it has become a buzzword is because of its high speed, right? It is because of its efficiency in getting results, in predicting outcomes. Okay, now when it comes to trademark, suppose you are a company, you want to register your own trademark, you will have to first search that whether such similar trademarks already exist. Okay, how are you going to search it? Doing so manually is a difficult task, right? Just searching through different websites, searching through internet, again, is a daunting task. And herein comes the role of AI, where it helps to search for the prior art. Now, prior art is a term in IP which refers to previous art or previous material sources in that particular domain. So, if you are a company seeking to register a trademark, or if you have come up with a product and you want to have a trademark on it, whether such trademark already exists, if it already exists, you cannot get that trademark registered. Or even if you get, right, there will be an infringement of the previous trademark. So, with AI, right, it becomes very easy to search for the prior art. It becomes easy to search and detect instances of infringement. So, what is infringement in IP? Infringement means when your intellectual property right is being violated. Okay, it is being used without your permission in a very simplistic language. Okay, so this is how the role of AI is when it comes to trademark. This is the positive role which is played. Now, suppose you have a trademark registered, right, across India, how are you going to detect whether somebody is copying your trademark or not? Okay, again, manually it is very difficult unless and until you go through some article where it is highlighted or some news report, so on and so forth. But with AI, with the computing power of AI, with the speed AI has, it is easy to detect such instances of infringement. So AI has this positive role to play when it comes for uh, when it is related to the domain of trademark. Okay, but there is also a drawback. Now, what I'm uh, portraying you is a broader picture of intersection of AI and IP. Okay, I will definitely come to the hands-on aspect, but before that, it is important to have a proper and sound base, okay, of what we are going to discuss, right? So, as AI can be useful in the domain of trademarks, right, it also poses certain issues. Okay, so as we discussed, so if you want to purchase a smartphone, right, and if it has the symbol of an apple, you will instantly recognize that this is iPhone. iPhone has specific features. It is believed that it is better than Android phones, and of course, that would make you select that particular smartphone. Okay, so your choice is dependent on that particular trademark. That trademark has a certain category of brand value. Now you know that AI, in a way, steers choices of consumers. Okay, so again, you must be aware. So if you're skimming through internet, or you're skimming through, say, for instance, YouTube, you automatically get recommendation, right, on the line of your search. So AI has that power in a way to manipulate, to steer consumers' choices. Okay. And through this, it is possible that the strength of trademarks can get weakened. So, whatever is the brand value of the trademark, that might be diluted. So, this is a broader, say, picture of the intersection of artificial intelligence and IP right associated with trademark. Okay. And then again, this all discussion which I'm having, I'm keeping in mind that how relevant it would be for you as academician. I understand that you must be academics belonging to different streams of science, technology, right, or even beyond. And all of you are very actively involved in research and development activities, in activities of entrepreneurship, where you encourage your students to, um, invent something or work for startups. So, in this environment, right, of research, development, entrepreneurship, it is very, very important that you have this knowledge of intellectual property rights. And AI being, slowly encroaching very fundamental aspects of life, it is important to understand how it interacts with different dimensions of intellectual property. Okay, so AI and trademark is one such instance. Second aspect which I want to highlight when it comes to AI and IP law is with regard to copyright. Now, whenever we talk about this different types of intellectual properties, say patents, say copyright, now each of these intellectual property have their own subject matter. So what does it mean? There are certain things which only a copyright can protect. There are certain things which only a patent can protect, right? And we need to understand this difference. So copyright, what does a copyright protect? It protects creative work of an author.
Pratita ma'am, sorry for interruption. Your slides are not visible. Only impact of AI on IP law, that slide is visible. Next slides are not visible.
Okay. Just let me share it again.
हाँ, है ना, हो गया लगा?
Now is it visible?
Yes, yes, yes.
Okay. So I haven't covered much. This is just the first slide which we are talking
Yes,
about.
okay, okay.
Okay. So AI and trademark is one aspect. Now AI and copyright. Now I said when it comes to copyright, we need to understand what exactly does copyright protect. Okay, so it protects creative works of author, right? Now, creative works, what category of work does a copyright protect? It can be related to literary work, it can be related to dramatic work, it can be an artistic work, right? Or it can be musical work. Okay, so if you are composing a music, you don't get a patent on it, you get a copyright on it, right? If you are drawing a painting, you get a copyright because that comes under the category of artistic work. Now, literary work is what all you do when you publish your research. So, research article, research paper is nothing but a literary work. So, it is protected under copyright. Okay. So, this we need to understand when we talk about different types of IP. what exactly that particular intellectual right protects is something we need to take into consideration. Now, when it comes to the domain of AI and copyright, there is lot of uh, intersection amongst it, right? So you must have been aware of recent AI related apps, or most of you might also be using it. Say for instance, Chat GPT, right? Or other such apps or chatbots. Okay. So whenever you ask something to Chat GPT, right, immediately it gives you an answer. Okay. Where does it get that answer from? It sources from different data. Now, AI, the fundamental of AI, of course, it emulates human brain. But on a technical side, what exactly is AI? AI is a pipeline of algorithms, right, which works to give certain prediction or outcome, right? How this algorithm work, what is the basis? The fuel for working of that algorithm is nothing but data, right? The more amount of data, the more amount of training data, the more efficient that particular AI system has to be, right? Now, when it comes to the domain of AI and copyright, there are ongoing cases with regards to this, where some AI application, it gives you some piece of information, a consolidated piece of information in a fraction of seconds. But where does it source this particular information from, right? Could be from certain websites, could be from research papers or blogs which are already been published. So while it source, does it take permission of the owners of such articles, right? This is something which is still under consideration. So whenever there is use of copyrighted work for training data, uh, legal issues emerge. Why? So copyright is when you create a particular work. What work? It could be literary work, it could be artistic work, it could be musical work. So whenever you create it, the moment you create it, you have a copyright on it. When it is violated, when somebody is using your work without your permission. So when this AI app gives you a certain consolidated piece of information in a matter of seconds, right? It certainly sources from a particular website or paper or report, right? While it sources, does it seek permission from authors of that different type of literary data? Okay, so these are the disputes. Another critical issue, and this is something which is of relevance to you as well, as research scholars, as academicians, is about the very nature of authorship. Okay, so an author under a copyright is somebody who creates a work. Now, what work you already discussed? It could be literary, dramatic, musical, artistic work, right? Now, AI is being extensively used in creation. Okay. So, for instance, assume you are a poet and you're writing a poem, say, um, on the occasion of Independence Day, right? And for few stanzas, you just ask Chat GPT, right? You take some clues from it and it instantly gives you and you include it in your poem. Okay. Now there is some contribution from AI. Now there are also instances where AI itself creates stories, AI itself creates music, right? Then can AI be declared as an author, right? Or can it be or should it be considered as joint authorship? Okay, so these are legal issues which are still persistent. So you as creators of work, more probably you are creators of a literary work. Now software, is protected, can be protected as copyright in different jurisdiction, right? Most of you must be related to computer science, right? You produce software or you produce or you write certain articles. All these are copyrightable materials. Okay. Inadvertently or intentionally, you use artificial intelligence. Okay. Then who exactly is the author of such work? Okay. Or what happens when artificial intelligence by itself creates a particular work which deserves a copyright? Does the law contain any provision to give authorship to such entities, to AI, right? So these are the ongoing issues under the broader domain of copyright. So far we have seen interactions of AI with trademark and with copyright. I will pause for a second just to know that all of you are following broadly what I'm saying. Right, thank you. Um, okay, so now we will move to the intersection of AI and patent. Okay, now patent, when it comes to this particular intellectual property right, it is a very technical thing, right? Now, we said that copyright is given to some kind of creative work, right? Is patent given to some work or some innovative work? No. Patent is given to an invention, right? What can be patented is an invention. Okay. So before we move into the intersection of AI and patent, right? We need to understand what exactly a patent is, and it is very important to get it thoroughly. I'm aware that you must have had, sessions on application of patents, how to file a patent, right? What I'm going to discuss today, and I feel would be relevant to you as research scholars and academicians, that if in future you decide to file a patent and it has an aspect of artificial intelligence into that, right? How you should proceed, what is the set of knowledge which you need to have. Okay, so this is my intention, that to give you a broader picture, right, of how AI is interacting with patent law. Now, there are two perspectives where in the invention you are using patent, and when it comes to AI and IP rights, AI broadly is used for managing different IP portfolios. Okay, so I'm not talking about that aspect where AI is used for managing of different IP portfolios. Okay, so we discussed key features of AI: proficiency, efficiency, its high speed, right? The high amount of processing power it has, its decision making ability, its prediction ability. Now, these are aspects which are very useful when it comes to organizing, managing certain IP portfolios, right? But rather, what I am focusing on is the aspect of AI intricately involved in the creation of an IP. Okay, so we discussed how AI is intricately linked with trademark. We discussed how AI is intricately linked with copyright. Now, AI itself can write stories, it can write poem, right? It can write dramas, or it can create even music. Okay. Now, how AI is related to patent? Are there any inventions or which include the aspect of artificial intelligence, right? Now, why AI is important? Because as we discussed, it is slowly entering even the fundamental aspects of our life. Okay. So be it the law enforcement agencies who use it in surveillance, or we may be victim of cybercrime where cyber criminals use AI. So we cannot say that we are, you know, quite far away from this domain of AI, right? We are nowhere related to AI. You are knowingly, unknowingly, right, a user of artificial intelligence or being used in a particular AI system when you provide data, right? So, knowingly, unknowingly, we are part of this AI ecosystem, right? And therefore, when it comes to inventions, okay, the use of AI in creating or in generating that invention cannot be, right? So when it comes to invention, how an invention has to be protected, it has to be protected through patent, right? But before that, we will first understand what exactly a patent is. So this is the broader agenda of my discussion today. So we will just skim through what are the basics of patent, right? Then we will discuss AI related invention. When I say that AI is being used to generate an invention, right? What exactly are these types of invention? Into what extent artificial intelligence is used for generating an invention, or is there any possibility where AI itself creates an invention without any human intervention? Okay. And then we will discuss this aspect of inventorship. So just that there is authorship in copyright law, there is an inventor, somebody who invents the invention. Now, who should be this inventor? If you're using AI, should AI also be named as inventor? Does our law has this provision of naming AI as inventor? Right? So that is something we would be discussing under this head. And then we will move on to the aspect of subject matter eligibility. That means, so what is subject matter eligibility? Subject matter means what area does that particular law cover? Okay, so we discussed that copyright is related to artistic, literary, dramatic, musical work, right? Then what is patent law related to? Inventions. Okay, but then what inventions, right? What type of inventions are protected through patent? So that is discussed under subject matter eligibility. And then when you have to actually obtain a patent, right, there are certain patentability criteria which you need to satisfy. Now, you may be aware of these criteria, but we will be discussing this in light of artificial intelligence. So this is the broad agenda of today's discussion. Okay. Now, when it comes to patent, what exactly is a patent? Patent is an exclusive right which is granted for an invention, right? So, focus is on exclusive rights. That is very exclusive to the person who invents. For what it is granted? For an invention. What type of invention? That invention could be certain product or it could be certain process, right? What does this invention do? It is a new way of doing something. Okay. So a simple thing, say a digital pen, right? Or you might be using certain tabs. So a simple thing of handwriting being converted to computer text, right? So this is a new way of doing something which has emerged, right? Rather than looking at a text and then typing out, you just write in freestyle on your screen and that automatically gets converted into text. So this is firstly a kind of an invention, right? It is a new way of doing something, or that particular invention offers a new technical solution to a problem. So new way of doing something or a new technical solution to a problem. A simple thing, say for instance, a sipper, a water bottle, right? An invention as simple as making a conventional water bottle or designing it in a such a way that you can easily use it while traveling, right? It won't cause trouble to you even if you drink water from that particular bottle, right? So you design it in some way. Now this becomes a new way of doing something. This is a new technical solution to the problem, right? Problem where in travel you cannot really drink water from a bottle just as you drink normally. Okay, so simple thing as this example, right, is nothing but a new way of doing something. How this way is, this is a technical solution to certain problem. So when it comes to patent, firstly it is for an invention, it is an exclusive right. How this invention is, it can be a product, it can be a process, right? Which is a new way of doing something or offers a new technical solution to a problem. Now, whenever you have to get a patent, so whenever you file an application, you have to provide the patent examination office with certain technical information about the invention. So that is something which has to be disclosed, and this is disclosed to the public in a patent application. So all patent applications are publicly available. Okay. And when we say that there is an exclusive right, and this broader debate I want to, highlight your attention to. IP rights, you know, are meant for protecting something. So you get an exclusive right over your work. So you have a copyright on the research paper. What does it mean? Nobody can use a part of it or completely without your permission, right? That means you're excluding somebody from using that work, and that work is protected. So there is this trade-off between the users and the authors, correct? So on one hand, you are protecting something. That protection gives recognition to that creator, that inventor. It also gives him or her certain commercial advantages. But at the same time, you're excluding the public at large from utilizing that invention. They can utilize only when that owner gives permission to use. Okay. And we say that IP is very important. How? How does it promote science, technology, research? How does it further spurs the growth of science, technology, and research? Just look at this simple thing that for getting a patent, you have to disclose all the technical information. Now, this technical information becomes available to the public, right? So the public becomes aware, okay, so this is the innovation or invention which has happened in this particular domain. If I am a researcher in that particular area, maybe I can work more, right? And create some new way of doing the same thing which is there in that invention, right? So, in a way, it promotes the development of science and technology at large. And then you must be already aware that it is for a limited period, 20 years. Okay. Now, while I discuss this AI and IP thing, and particularly AI and IP patent intersection, I am focusing on the Indian Patent Act. Okay. So broadly, our discussion would be surrounded over that because the time is limited in this limited time span. That is the only thing which could be covered. So patent lifetime, what is the life cycle of a patent? There's an invention, you apply for a patent, right? Then there is a prosecution phase where the examiner sees whether you have satisfied all the criterias or not. Patent is issued, right? And ultimately it expires after 20 years. Okay. Any questions or comments so far? Or we can take it towards the end?
Madam, as you told that patents can be disclosed to the public in my application, so that we
Yes.
have that it is my right to protect the information. I should not disclose the information. No, I have a patent means I have some information, so it is my right. I could not disclose the informations.
Yes, I get your point, what you're saying. Now, if you look at the definition of patent, it is an exclusive right. I haven't included the other aspect. Exclusive right of doing what? Excluding others from using your product or process, from preventing them from importing it, from preventing them to sell your product or process. So when you get a patent, or what type of right you get a right to exclude others from doing what, from using your product or process. Now when you give that all details in an application, I get your point. What you mean is patent is meant to protect, and if I'm already disclosing it, what protection I am getting. Now the requirement of obtaining a patent. So when you file a patent application, there is a certain specification which is required. You have to write the abstract, you have to write the claims, and you have to uh, inform in that application all the technical information with regards to your product or process. Now this is publicly available, right? But reading that particular information, can somebody, if somebody really forms a product, or if it is a process patent, somebody just copies that process, right, and uses it, now that becomes an infringement of your patent right. And that is somewhere where you can file a case against that particular entity doing so. Okay, so when you get a patent, you are excluding others from certain performing certain functions. Now, what are these functions? You are excluding others from using your product. You are excluding others from importing your product. You're excluding them from selling or making that product. So making is also involved. It's not just use, but also making. So if you say that you have given a patent or filed a patent applications, and you have described in every detail, possible detail, the technical information about that product, nobody can make a product on the basis of that information. If it is made, it is violation of law. So therefore your protection is of course there, but at the same time, the disclosure of all this detail in patent application, in a way, as I said, spurs further research. Okay, I hope I have made it clear. Yes. Okay. Now let's move to this aspect of AI related invention. Now we are talking about patent. Patent is given for an invention. Okay. And this invention could be a product, could be a process, right? Now, in what way AI can be used to make an invention, right? Now, again, there are no defined categories as such. I prefer to follow, the broad categories which I would be mentioning in this slide. So this is being sourced from the book on international perspective of AI and patents by Walters Kluwer. Again, this is not an exhaustive way of categorizing AI related invention. You can name it in any other way. Tomorrow I can also name it in any other way. So invention which is AI assisted, or invention which is completely made by AI. So we can use different terms. And unfortunately, it is this lack of proper definition, right, of AI and its involvement with regards to creation of an invention. That is what something which leads to problems in law, in patent law. Okay, when we will see how. So when we say AI related invention, there could be different categories of it. Firstly, it could be an invention of AI, right? So that means it could be an invention of a completely new AI algorithm or a AI model. Okay. So this invention is completely about AI. This could be one possibility. Second possibility is invention of an AI implementation. So where, for instance, there is a creation of a system or process of broad application using known AI technology, and plus there are some additional elements. So for instance, there is an AI technology or AI system which is used in medical diagnosis. Okay. And using that medical diagnosis related AI system, you are creating some further process or further system. So creation of a system or process of broad application using a known AI technology, right? Plus you are including some additional elements. Could be you're adding into some hardware so that becomes a product, right? So these are the broad possibilities. So it could be an invention of AI as such. So invention we discussed, it is new way of doing something. So you can come up with a new AI model, right? And that deserves protection under patent law. Or it can be an invention of an AI based implementation where there is an AI technology, right, in place, and you are using that known AI technology to create further system or process. Or it could be a new application of AI. So we discussed where AI is used basically in making decision, or helping or aiding a particular decision, supplementing human decision. This is where AI is broadly used, say weather prediction, medical diagnosis. AI supplements human decision. So wherever there is a new application of AI, where it is helping to make a particular decision. So where a particular smart car should stop, seeing a red signal, seeing a human being crossing or a animal crossing the road, where it should stop, right? You come up with such an application of AI, right? Or it is somebody or something where it is helped to make a decision, right? So this could be one category. Now understand that these are broadly related to software. Okay. So invention of AI, invention of new algorithms or model, it is nothing but software. Similarly, in second also, where uh, these additional elements, if it is not about any hardware, then it is purely a software. A new application of AI where it helps to make a decision, that again is a software, right? Then there is a fourth category which is possible, and it is about inventions made using AI. Okay, so a human inventor can use AI. For instance, there is an AI system or an AI model which is used for medical diagnosis of a particular disease. Okay, now using this, I being a researcher in the medical field, I use this AI system, right, to come up with certain other invention related to that disease. Could be, say, a particular device which can help me to form more better predictions, right? So where you are using AI to make an invention. So employed by a human innovator to solve a particular problem. And then there is also this possibility. Now, this is a possibility to a certain extent, and there have been, scarce example, I can say, where inventions are totally made by AI itself. And therein comes this problem of inventorship. Okay, and there has been one recent case related named as Dabis, which we will shortly discuss, and it has been, contested in several jurisdictions: US, South Africa, Australia, India, UK, right? That whether AI can be uh, a human, can be said to be an inventor or not. Okay, so these are the broader applications. So when I say AI related invention could be patented or has to be patented, then what exactly are these AI related invention? It could be an invention of AI, could be an invention of an AI implementation or a new application of AI, inventions which are made using AI. So where a human innovator, right, when he has to solve a particular problem, uses that AI system, or AI independently makes certain inventions. So these are the broader possibilities of invention which is possible when it comes to artificial intelligence, right? Now, we move on to the aspect of inventorship. So when in copyright law, we say that the creator of a particular work which is copyrightable is known as author. Author is the term used. Now we say patent is granted for an invention. Okay. Now, an inventor is somebody who invents that particular invention, right? In a very simplistic way to understand. But again, as I said, we would be focusing on the Indian Patent Act, the Indian law. So when it comes to inventor, does Indian law specifically define that yes, XYZ person should be an inventor or XYZ category of person should be inventor? Or what is an inventor? Who is an inventor? No. Okay, so this is a gray area in law. Then what are the provisions with regards to inventorship and how AI is an issue here? Okay, so Section 6 of the Indian Patent Act, it provides that the following persons can make a patent application. Okay, it doesn't use the term inventor as such, but it says that who can make a patent application, either jointly or alone, a person claiming to be the true and first inventor, right? That particular person who is filing an application, he should be true and the first person to invent that particular invention. Such person can file a patent application, or it could be even a group of persons. Or and assignee of the person claiming to be the true and first inventor. So assignee, so I am the inventor, right? But for some reasons I'm not filing an application, but rather I let my research student to do so. So I assign them that on my behalf, you file the patent application. Okay. And then it could be legal representative of any deceased person who immediately before his death was entitled to make an application. Okay. So inventor as such is not defined or expressly it is not mentioned. But rather what is mentioned under Indian law is that who can file a patent application. So we saw it is a person who claims to be true and first to inventor, or it could be an assignee of such person, or it could be legal representative of any deceased person who was immediately before his death entitled to make such application. Now, focusing on this term or expression person, this person term is defined in the Patent Act, right, under Section 21S. And it says that it includes the government, right? So, a person, does it mean just one natural person? No. There is a broader understanding of the term person under Indian law. So, there can be a patent granted to a particular state government, right, to government of India, right? In that case, it is a person claiming to be the true and first inventor. So this term person includes the government, right? Now this has to be read in conjunction with the corresponding definition under the General Clauses Act 1897, where a company shall include any company or association or body of individuals, whether incorporated or not. Okay, so the idea of personhood is very broader. So, inventor, if you say who is an inventor or who could be an inventor in India, can it just be a natural person or a group of natural person? Yes, they can be, but apart from that, person also implies government. Okay, so there is a broader understanding of this particular term.
Ma'am, excuse me.
Yes,
In case of innovation by AI,
yes.
who will be the inventor and assigned?
If I am able to hear you clearly, you are asking in case of innovation by AI, who will be the inventor?
Madam,
Is
in the different categories, you told that inventions made using the AI and inventions made by AI.
yes.
So that if inventions are made by AI, who will
Hmm.
who will claim the patent?
Yes, yes. So
Yes.
that is correct. So that is something which is under discussion. And again, as I said, this is a possibility. And this possibility is seen in this Dabus case. So Mr. Stephen Thaler, he had filed this application where he listed AI as one of the inventor. Now, this Dabus, if you read here, it is device for the autonomous bootstrapping of unified sentience. So it is a particular device which has a substantial component which is made by AI. And therefore, Stephen Thaler, he has filed applications in several jurisdictions in UK, in US, in Australia, right? Claiming that AI is an inventor for when it comes to this particular device. But again, that is why I say that this idea of person, this idea of inventor, there is a lot of gray area here. It is a gray area. Why? Now, most of these applications or his claiming that AI is an inventor were rejected. It was rejected in UK, it was rejected in Australia, in USA, on the basis that inventor can only be a natural person. Now, even if you see different rulings by courts in India, it is evident that a person claiming to be an assignee must be a natural person, right? So, sorry, person claiming to be an inventor must be a natural person, right? However, the person claiming to be an assignee, just as we discussed in this side, a signee of a person claiming to be the first true and first owner, it could be a legal person. Now, in India, a company is said to be a legal person. Patent Act says person also includes government. Okay, so it could be a signee. But when it comes to um, person who is seeking inventorship, it is a natural person. And if you go through the rulings with regards to this particular Davis invention in different jurisdiction, it was denied. AI was denied inventorship on the very fact that inventorship as a concept is only associated with natural persons. So presently, there are limitations in the current law to recognize AI as inventors. Okay. This is just an instance of Indian law. Again, as I said, in US, UK, where this case had been ongoing, there are instances where this has not been considered as an inventor. AI was not considered as an inventor. Okay. But on a very moral basis, is it really appropriate to ignore the contribution of AI? Now, these different categories which we discussed, right? Again, these are broad categories, and as I said, this is not an exhaustive list, but I found this categorization very logical. Therefore, I have included here inventions made using AI, inventions made by AI. The role of AI, can it be ignored? Right? Even if it is about inventions made using AI, substantially you are depending on the prediction or outcome of some AI system, right? So your invention finds logic, finds meaning because of the contribution of AI. But at present, the laws are not that appropriate where the contribution of AI could be recognized. But I also want to point your attention to this fact that when it comes to this Davis invention, South Africa was one such country where this recognition of AI as an inventor was considered. It was considered positively. Okay. And as we will progress further, you will see the developments which are taking place in India as well. How the courts recently have been, recognizing the importance of this emerging technology of AI, right? And they have highlighted the need to change the laws accordingly. Okay, right. So this was about the concept of inventorship. Now it is important for us to understand the subject matter eligibility. As I said, subject matter, what exactly are the inventions which are patentable in India? To understand it very in a literal sense. So, is the subject matter of that invention eligible to be protected as patent? Right? This is something we have to see. Now, there are certain countries across the globe, when it comes to subject matter eligibility, they enumerate. Okay, so for instance, US, it says that if an invention is related to a machine process, right, then it comes under subject matter of patent law, right? Any invention which is related to machine is, for example, machine is patentable. But focusing on the Indian Patent Act, it doesn't tell us what can be patented or what inventions can be patented. Rather, it opts for the exclusion approach. So, Section 3 of Indian Patent Act tells us what are the categories of invention in India which cannot be patented, right? Now, are there any specific provisions governing AI related subject matter? Presently, no, right? However, when it comes to any patent application which has an AI element into it, that particular invention is examined under the category of CRI, that is computer related invention. Okay. But when it comes to computer related invention, attention has to be paid to Section 3K of the Act. Okay, as I said, Section 3 enumerates certain exclusions that this cannot be patented, this cannot be patented. So section 3K, which is related to computer related inventions, let's see what it is. It says a mathematical method or business method or a computer program per se or algorithms are not invention. Okay. So it clearly excludes the core software or pure software component from being protected as patent. Now, AI, we discussed what is AI broadly on a technical sense. It is a pipeline of algorithms. It processes certain amount of data, right? It gives certain output, right? There is certain methodology which is applied there. Okay. Basically, at the core of it is mathematics, right? Algorithms, computer programs, but very clearly, the Indian Patent Act excludes this thing from being protected as an invention. Then, how should we proceed if your invention has an aspect of AI? Okay. For this, we need to pay attention to these revised set of guidelines for examination of computer related inventions, CRIs. Okay. So, these guidelines have come in 2017, right? It says inventions which involve the use of computers, computer networks, or other programmable apparatus, and include such inventions having one or more features of which are realized wholly or partially by means of a computer program or programs. So, any AI related invention is considered as computer related invention. Now, what exactly is computer-related invention is something which the 2017 guidelines enumerate. So, in CRI, anything which involves use of computer, computer network, programmable apparatus, right? Wholly or partly, something which is achieved wholly or partially by means of a computer program or programs. Now, broadly, of course, 100% we can say that it can be readily juxtaposed on the AI thing. Okay, so AI related invention in India is examined as what? It is examined as computer related invention, right? So all the nuances of protecting software through patents, all the debates, analogically, we can relate it to the AI related invention because at its core, it is considered as CRI. Now, when it comes to determining exclusion of this CRI, the focus should be on the underlying substance of the invention, okay, and not the claimed format. So, suppose you are coming up with an invention which has an AI aspect, right? But you need to remember section 3K. What cannot be protected? Mathematical method, business method, computer program as such, or an algorithm, right? You devise a new algorithm. If you recall the first category, where you are making an entire new AI system or designing an AI algorithm. Algorithm per se cannot be protected, right? But is there any way where we can encapsulate it and fit it into the definition of CRI, right? Now, to do this, to fit your invention into CRI, AI related invention into CRI, right? What you need to focus upon is the crux, the underlying substance of that invention. So, that is where comes the role of drafting your patent application. How are you going to draft it? Are you going to say that, oh, I need a patent on the algorithm I have designed? Rather, if you are able to focus in your patent application on the broader functional aspect, right, then the probability of getting a patent increases. So if you just go to the patent office and seek patent on algorithm, is it possible? No. Or some business method, some mathematical method? No. At its core, AI is nothing but set of algorithms. It's all mathematics. Correct. So you need to encapsulate it in such a way that the focus of your application is on the substance of that invention, okay, and not the plain format as such, right? Now, there is this recent case 2019, Ferry Delani versus Union of India, by Delhi High, it took place in Delhi High Court, wherein it was noted, and as I said, how slowly you can see there is awareness on the legal front with regards to AI and other emerging technologies, and how it is prompted that yes, there are certain laws which needs to be changed. So, or amended. So, innovation, the judgment says the innovation in the field of AI, blockchain technologies, and other digital products would be based on computer programs. And this is the future, right? The court admits, and it is, even if you go through several reports, there was one report by Rajya Sabha, right, which came up uh, and talked about the need to look into patent laws and rules pertaining to AI and other technologies, right? So, of course, we have admitted that AI is going to be the future. It is very much intricately linked. And there is recognition and acknowledgement of this particular fact, right? But while we acknowledge this, there are these limitations of law which come into picture, right? And as an applicant, you need to be aware of these limitations so that to escape it, find a roundabout and ultimately make your invention patentable. Any invention which has an AI element into it. So, innovation in the field of AI, blockchain technologies, and other digital products is sure to be based on computer programs. This is what we have been discussing. AI at the end of the day is what? It is algorithms, it is mathematical method. However, the court said the same would not become non patentable simply for that reason, right? Simply because AI has computer programs, you cannot say that we won't grant patent, right? So slowly there is recognition, cognizance of this fact, okay? That yes, what Section 3K says, it completely excludes computer programs per se from being patentable, right? But why this judgment is important? Because it acknowledges AI and blockchain, the role, the constructive role played by it. And it also acknowledges the fact that any digital product, right, is going to be based on computer program. Any digital product which is related to AI blockchain is surely to be based on computer programs. Now, because computer programs are excluded under Section 3K, right, you cannot say that they are not patentable, these inventions. Okay. Now, of course, there is no clear cut uh, a set of legislations or provisions in our patent law which deal with AI related invention till date, right? But you can see how slowly there is a shift and there is acknowledgement. So, examiners cannot reject inventions relating to AI under this computer program ground. Okay. But rather, it imposes the obligation upon them to assess the technical effect or technical contribution of the claimed subject matter, right? And herein comes the role of disclosure. Whenever you are filing a patent for an AI related invention, right, the way you disclose it, the way you fill up your patent specification, what should be highlighted again, as I said, it should be encapsulated as CRI, it should be encapsulated in a problem solution approach. The more broader functional framework could be, portrayed or highlighted, right? And most importantly, that particular application should be able to show very prominently the technical contribution it is making to that subject domain, right? Or the technical effect it is having. So, describing the objective training problem and implementation of the technical solution in a method or by a device using AI model, right? And then you can say how it differs from the previous invention, bringing into AI how AI is changing the way. So if it is about a business method, is it patentable in India? No. Section 3K clearly excludes business method. But through this judgment, it can be inferred that can do such AI related inventions be rejected on those pure grounds of 3K? No. If that particular invention is able to show certain technical contribution, it is able to show certain technical effect, right? At that point of time, it can be considered under subject matter eligibility. So at that point of time, it becomes eligible to be protected as patent. So for instance, there is invention relating to a machine learning algorithm, right? How are you going to draft the application? In that application, it is important for you to highlight the crux of that algorithm. Say you can do a pseudocode, right? If it is an algorithm of an AI system related to a medical diagnosis, don't go for filing a patent applications which narrates the algorithm as it is, right? Rather put it in an abstract form, highlight the technical contribution that is going to make, and in this way you overcome this hurdle of section 3K. Are you following? So about invention relating to, say, for instance, application of AI, where a lot of attention is put on training data. Okay. So where AI has to predict something. So how does it predict? So the rest is, for instance, it is about weather prediction, right? So how does it predict? It predicts through sourcing different data and processing it. Now, if in your invention you identify those sources, you tell or describe about the nature of data. So that is going to add an angle of credibility, that is going to add this aspect of technical contribution, technical effect. And therefore, despite on surface belonging to the excluded category of 3K, this AI related invention can be brought under subject matter eligibility. I hope you are following this. It is slightly technical, uh, but I hope I am able to make some sense to all of you. Okay, if there are no questions or comments so far, let me quickly take you through the other two criterias of patents. First is novelty, right? So under the Indian Patent Act, what is concept of novelty? Novelty for an invention, right? So that invention, it should not be published in India or elsewhere, or it must not be in prior public knowledge or prior public use within India. If you satisfy these two criteria, then your invention is novel and therefore it deserves patent protection. Okay. Uh, Now, new invention, the Act also highlights upon that, means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of patent application with complete specification. That means the subject matter has not fallen in public domain, or that it does not form part of the state of the art. So prior art, state of the art, these are the terminologies which you need to keep in mind when it comes to the criteria of novelty. So foremost, what an examiner will check, patent examiner will check, that whether there is an aspect of novelty to your patent application, to the invention on which you are seeking patent. How he will check whether it is novel or not? He will check whether this invention has been published in India or anywhere in the world. He will check whether something, so if it is about some product, right, he will first check if it is already in public use in India. Okay, so this is about uh, novelty, right? Now, as we already discussed, that AI is broadly considered as CRI, computer related invention. So, uh, This broadly relates to software patents, right? And when it comes to software patents, searching for prior art is a very difficult thing. Okay, so you are coming up with a software, right? In its very nature, it is very conceptual. So hardly it is there that a software is surrounding just one concept. There are multiple concepts, right? Then there is bulk of information which is available prior to filing of that software patent. So when you file an application, right, for a patent, you do your research of prior art. Okay. In normal circumstances or product or process otherwise, right, it is still easier to know whether it has been published before, right, or it has been in prior public use. But something like software, the bulk of information or the prior art which is there, it is immensely huge, right? And it is a daunting task to go through this huge set of information, right? So again, with software, this is the thing. But when it comes to AI, which is again a more advanced nature of software, searching of prior art is even more problematic, right? Why? Because basic functioning of AI is itself based on trained data. We discussed that there are it sources from different, the data is sourced from different sources, right? It is processed, a prediction is there or an outcome is there. Now, this basic functioning itself involves a lot of data for a particular AI system. Now imagine the prior art search which has to be carried out for such a system. Okay. So for software, it is anyway difficult, but for software related to an AI invention, it is even more difficult, right? And therefore, if you're opting to file patent for an AI invention, right, you have to be very careful with this criteria of novelty, right? And then there is this second aspect of inventive step, another patentability criteria. So what exactly is an inventive step? A feature of an invention that involves technical advancement as compared to the existing knowledge. So we discussed that simple example of water bottle, right? Or that particular invention has economic significance or both. And this aspect is very important, and we would be highlighting on this. Makes the invention not obvious to a person skilled in the art. Okay. So the criteria of novelty, I hope it is clear. What does the criteria of inventive steps suggest? Okay, firstly, there has to be a technical advancement over what has been happening previously. Then it would be considered that yes, there is some kind of an inventive step in your invention, right? Or it should have economic significance or both. And then, very importantly, whatever invention you are filing a patent on, it should not be obvious to a person skilled in the art. Now, it is usually termed as Fosita, person having ordinary skills in the art, Fosita. Now, this is a very key element, okay, when it comes to assessment of obviousness. Now, this is also called as non-obviousness criteria. So, whenever your application goes to an examiner, firstly, of course, novelty would be seen, right? Then, whether an inventive step is there or not. Now, how would an examiner determine whether the inventive step is there? So, if it is an invention, right, related to a pharmaceutical sector, say it is about a production of certain category of drug, okay? So, the examiner will look at that application through a lens of an hypothetical, non inventive person, right? Who this hypothetical person is? It is a person who is having ordinary skill in that particular art. The ordinary means something which is just required, not of a standard of a very high expert, right? Something which an average person or averagely read person in that particular field would have knowledge about. Okay. So for him, that invention should be not obvious. Okay. But who will be this ordinary person, or who will be this hypothetical person when it comes to AI related invention, right? Now, AI related invention are itself quite complex when it comes to inventions of other categories, and we discussed the reasons what makes AI related inventions different, right? So therefore, accurate identification of ordinary person is where the challenge lies, right? So one AI system, AI model may be sourced from different sectors, right? Could be chemical, could be mechanical, and it can have application in the field of medicine, right? Now, the challenge before the patent examiner is about identifying of such a person, or taking a lens of such an hypothetical person who might have ordinary skills in these art. Now, there are multiple aspects. It's not as simple as a person having skill in a particular art, right? So, when it comes to AI and AI related invention, the bar or threshold is, of course, very high. Okay. So this was broadly about the different patentability criteria and the challenges it might pose. Just on a closing side, a brief set of recommendations, which has emerged from different research, right? So AI related invention, of course, it has to be shown as CRI. So it has to be encapsulated. It is by default considered as a CRI, computer related invention. But for obtaining a patent, you should show that there is some improvement to CRI. That means what? There is something more efficient or some other performance metric which indicates better performance over previously known solutions. Okay. Then you need to ensure that the technical solution is disclosed. So this is a key which you need to remember when you file an application for AI related invention. And wherever possible, do include the parameter ranges, be it for inputs or output data sets, right? So that the presence of inventive step would be more evident. So these are broadly the aspects which you can remember. And towards the end, I would like to emphasize on the broader aspect of why this entire discussion we are having since last 1 hour is relevant, and particularly in the Indian context where you and me are academicians, research scholars, right? And we teach and encourage students towards entrepreneurship, and we promote, in a way, try to promote employability through our teaching and research skills. We cannot ignore this fact that India is at the cusp of AI revolution, right? We have been laying great emphasis on research, on education, even when it comes to policy framing related to AI on the global framework. India is, keeping or it's the role which India is playing in the broader policy framework is also very prominent. And we cannot forget this fact that, ultimately we are a knowledge economy, or at least we are moving towards this idea of knowledge economy. So, what is a knowledge economy? An economy which is based on goods and services which are sourced from knowledge, right? So when it comes to knowledge, it comes to ideas. When it comes to ideas, it comes to protection of those ideas, and it comes to gain commercial advantages from those ideas and its protection. And that is where the role of intellectual property comes, right? And that is why it is really significant to understand this interlinkage between artificial intelligence and intellectual property, right? And if you go through the recent trends, India has been an emerging jurisdiction for patent filing in field of AI, right? So there is a lot of surge in the patent filing applications with regards to AI. And of course, it has huge potential when it comes to commercialization of AI related inventions. So, on this note, I would like to end. And in case there are any questions or comments, I'm welcome for that. Thank you.
Thank you, madam.
Is anybody? Any question from the participant? Please answer.
Madam, are we audible? The mic mute का बघा इथं इथून mic इथून mic mute का बघा बोर्डावर.
Hello, ma'am.
ते बंद करा तर त्याचं काही गरज नाही हो.
Can I ask one question, ma'am?
ते कशाला जोडणार आहे मित्र बोर्डच आवाजात होता ना फक्त बोर्ड तिकडून कसं काय आवाज ते बंद कर ना तर काय काम मॅडम am I audible now?
Yes, yes, yes,
Some participants would like to question ma'am.
yes.
Ma'am, suppose we develop a predictive model using AI for example, plant disease prediction. Okay. We have
Sorry,
like
please, can you please be louder?
hello, ma'am. Am I audible?
Yeah, yeah, now you are, yes.
My question is, suppose we develop machine learning model for predicting the plant disease. Okay.
Okay.
Means by accepting the image of, for example, leaf images, detect
Mm-hmm.
type of disease that plant has. So
Mm-hmm.
suppose we develop the machine learning or deep learning algorithm. After that, suppose we develop an application like mobile application. Can
Right.
we go for patent, Indian patent?
Yes. Right. So, again, there are two aspects. There could be a process patent also on the methodology through which you have applied it, right? And there could also be a patent on the end product, the mobile application as such. Now, when it comes to mobile application, again, by default, it is nothing but software. And if it is about software, you need to understand the guidelines for computer-related invention. And what you need to show in your application is about the particular specific technical contribution it is making. How before your proposed invention, what was different and what is the technical difference your invention is bringing about. If you are able to focus on that aspect, it is very likely that the patent could be, followed up.
Okay, thank you, madam. And one more thing, when we are suppose we develop any hardware for that instead of
Yes.
developing any application, if you develop any hardware for the farmer and that particular image is captured by that particular device,
Yes.
after accepting the input, then our algorithm will predict which type of disease.
Yes. So see, whenever then hardware component is involved, the things are comparatively very easy. Right. Now, again, 3K is pertinently about exclusion of computer program, business method. But when there is an hardware component involved, it is a product, right? And it is easier to show some technical contribution or technical advancement through that product. So that is a comparatively easy thing to achieve.
But mostly it is for the design pattern.
Yes,
And
design
we
patent.
this
So there is this concept of design. So there is a different legislation in India about protection of design. So you can protect the design of your end product separately. Okay. But patent, as I said, would be on the invention, and invention would be where you are able to show that technical advancement. So design you can separately protect as a design under Design Act. Okay, but on patent you can on that particular invention you can apply through whatever are the provisions of the Indian Patent Act.
okay. Last question regarding this topic. That is, when we are developing such a model, and if we use the secondary data, then is it acceptable for filing the patent process patent?
So that is the catch. So I also mentioned briefly somewhere in my slide that if you are using or making an invention which primarily relies on data, it is always better that you indicate the sources or at least the range of the parameters, right? That is going to add credibility and assurance of the proper technical effect, and it will also help you to counter future copyright violations with regards to data if at all it occurs. Okay, so if you are able to, after all, what is IP? You need to understand that it is about recognizing somebody's right. And when you are using that particular IP product, you need to seek permission. Okay, so data, what data is that data publicly available? If it is a publicly available data, then it may not be a problem. But if it is a data which, if the AI system is designed such, which requires a data from a specific, say, entity, then it is always logical to first seek permission from that entity. That should be done to avoid later repercussions.
Okay, madam. Thank you so much.
Okay, thank you.
Yes, any other participant want to ask question? Thank you, ma'am, for such an effective session. You were sharing the knowledge of impact of AI on IP law, AI and patent, AI related invention. Thank you, ma'am.
Okay, thank you. Thank you. I wish you all the best for the upcoming sessions. Good luck. Thank you for the invitation. Yes.
With this, we conclude second day of our FDP on IPR. We truly appreciate your engagement and the enthusiasm from all the participants. Looking forward to the another insightful day tomorrow. Have a great evening.